Okay, good. Oh my goodness, I sound different. Aloha mai kakako. Good morning, everyone. So nice to see our commission back in action, and everybody's here today, so I welcome you all. This is the October 4th, 2023 Land Use Commission meeting. This is an in-person meeting which is being held at the Airport Conference Center, Ohia Room, Hawaiian Airlines Terminal 1 building. And this meeting is open to the general public. Court reporting transcriptions are being done from this Zoom recording of this meeting, but the Zoom recording is not being broadcast, just for your information, outside of this room. It's only for recording purposes so we can prepare minutes from the Zoom recording. We also have a brand new microphone system, so thank you to the staff for bringing that forward and making it work. And I think everybody's got instructions on how it operates, but in general, if you're called upon to speak, or if you'd like to speak, there's a talk button, and you need to hit that talk button. Also, just FYI, is that the chair does have the option to turn off your microphone or any of the microphones at any time if we so choose. And Ariana, you also have that capability from your station, is that correct?
Yes.
Okay. For all participants, I'd like to stress the importance of speaking slowly, clearly, and directly into your microphone. And before speaking, please state your name and identify yourself for the record. So I'm speaking, this is Dan Giovanni, I'm the chair of the commission. Even though this is an in-person meeting, please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. So this is currently 9 o'clock. We're scheduled here for the day, but I will advise that we will be taking breaks from time to time, typically 5 to 10 minutes every hour. I am Dan Giovanni, and I have the pleasure to serve as the LUC chair. We currently have 9 seated commissioners. That's 100% of our allocation. Along with me are Commissioners Lee Ohigashi, who is the first vice chair, Michael Yamani, the second vice chair, Gary Okuda, Mel Kahele, Kuike Kamakea Ohelo, Mr. George Atta, Mr. Brian Lee, and I'd like to welcome our newest commissioner from the Big Island, Nancy Carr-Smith. Welcome. Also in attendance are our Land Use Commission Executive Officer, Daniel Orendanker, LUC Chief Planner, Scott Derrickson, LUC Staff Planner, Martina Segura, LUC Chief Clerk, Ariana Kwan. Incoming but not here and present as of yet is LUC Attorney General Dan Morris. So Mr. Morris is expected to arrive within the next 15 minutes or so. We will continue with the business of the commission, and if there's any particular part that would require Attorney General presence, I will defer that portion of the meeting and ask for a motion to amend the agenda accordingly. I'd like to note that Commissioner Ohigashi, who will be excused from the meeting at approximately 11:30 a.m., whether we're finished with our business or not. I understand that Mr. Ohigashi will be taking an international trip later today. So he needs to... What's that?
For all of you. I represent you.
He will represent us at the whiskey bars in Japan, yeah. Our first order of business is the adoption of minutes from our meeting of June 21 and 22 of 2023. Ms. Kwan, has there been any written testimony submitted on the minutes?
No, Mr. Chair.
Are there any members of the public who have signed up to testify in the adoption of these minutes?
No, Mr. Chair.
Thank you. Commissioners, are there any corrections or comments on the minutes? If not, is there a motion to adopt the minutes for the June 21, 22, 2023 meeting?
Mr. Chair, I move to adopt the minutes.
So moved by Commissioner Ohigashi. Is there a second?
I second.
Commissioner Atta has seconded. All in favor of adoption of the minutes, please say aye. 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 Any opposed? The minutes are adopted. Thank you. The next agenda item is our forthcoming and tentative meeting schedule, which will be presented by our Mr. Orendenker.
Thank you, Chair. On October 18th and 19th, we will be on Maui for the ELC and WDV status reports and for the WDV motion for extension of time. November 1st and 2nd are currently open. November 15th, we're planning on having a virtual meeting with regard to the proposed rule amendments. On November 16th, we're having a hearing in Kona on the WHCC-YO limited partnership matters. December 6th and 7th are tentatively scheduled for Oahu, but we're not sure whether those are actually going to happen yet. We will communicate with the commissioners on that. December 20th and 21st is currently open, and that takes us through the end of the year.
Okay. So, Ms. Kwan, I know that you had surveyed the commissioners for their availability through the end of the year. I, for one, have had some changes in my plans, so I'll send you an update on my availability. For example, I don't think I'll be available December 20 and 21. Okay, may I have a motion from a commissioner to change the agenda sequence of items? I'd like to suggest that we go to that we skip the port where we may go into executive session and instead proceed with a discussion and approval to proceed with proposed amendments to our Land Use Commission administrative rules. May I have a motion to modify the agenda accordingly?
Mr. Chairman, I so move.
Thank you, Commissioner Ohigashi.
Mr. Chair, second.
Thank you, Commissioner Yamane. So we'll now proceed with the discussion and approval to proceed with proposed amendments to the Land Use Commission administrative rules.
Thank you, Mr. Chair. I'm going to move over to the other table so that I can answer questions.
Very well. I just like the record to show that we do not have any members of the public present at this time, so I have not asked for whether or not we have any public testimony on this agenda item. Ms. Kwan, has anybody submitted any written testimony on this agenda item?
Ken Church submitted testimony on September 29th.
And that has been made available?
It is posted to the website.
Thank you very much.
Thank you, Mr. Chair. This is a preliminary request to the Commission for us to actually draft rule amendments. We have had a number of Supreme Court and federal court cases that have come down recently that require modification of our rules. We've also had some statutory amendments, and I'll go through those briefly in a minute. When we do a rule change, we usually also go through and do administrative changes, changing some of the archaic language to more modern language. Also changing things that are confusing so that petitioners will know better how to handle certain issues. At this point, we're just asking for permission to draft the changes. At a future meeting, we will come back to the commission. Prior to that meeting, we will distribute proposed rule amendments for the commission's review and the public's review. And then we will hold a meeting for the commission's approval to submit those rules to the Department of Business and Economic Development and the governor's office for permission to go out to public hearing on the rules. It's a very complicated process. The actual amendments can be modified at that next meeting by the commission, if so requested. And we can make those changes then. Once we've gotten approval from the governor's office to go out for public hearing, we will go take, the commission does not have to do this, by the way, for the public hearings on the rules. The staff can do it. We'll ask for comments from the general public. We'll probably hold a couple of meetings on a couple of different islands. And then we will take those comments, and if we feel that they justify further amendment, we will come back to the commission again with another version of the rules, and then request permission to submit those for approval by the administration.
Can I ask you, I'd just like the record to show that Mr. Morris has arrived and is now in attendance.
And I apologize for my late arrival, excuse any inconvenience I've caused. So
When you want to talk, you gotta hit this button.
Red light, red light.
The red light.
There.
Okay,
There you go.
So sorry for my late arrival, excuse me.
there you go.
Okay.
Back to you, Mr. Rondecker.
Okay, once we submit the final version to the governor's office, it goes through, well, actually it goes through DBED, the governor, the BNF, and then the governor's office. And then we have to file them, assuming we get approval, with the lieutenant governor's office. This process, in our experience, takes 8 months to a year. It's just not a quick process. And a lot of that time is spent waiting for DBED and the governor's office and BNF to review the rules and sign off on them. Okay, so here we are. This is just the beginning, and I will now go through some of our thoughts on some of the areas that need to be changed. We've actually identified about 42 places where housekeeping amendments can be made to fix grammar, spelling, and reflect our need for ADA compliance. There are 4 proposed areas where we think the rules need to be amended that reflect rulings in court cases. And then there are another 9 additional definitions or new sections that clarify how the rules are supposed to work and what information the petitioners are supposed to apply. One of the areas that we're talking about changing the rules of a substantive nature is something that we've dealt with in the past couple of years, and that is if somebody asks for boundary interpretation, we give it to them, and they don't agree with us. Right now, the rules don't say anything about what happens. We've just been treating it as a declaratory ruling. It will continue to be a declaratory ruling, but for the sake of petitioners, we're going to clarify the process in the rules. We're also looking at clarifying some of the sustainability principles that are required in applications as the process of developing sustainability rules has changed, and there's been more information as regard to what certain requirements are for sustainability. We're going to incorporate some of that new thinking into the rules, so it's clear for the petitioners what they have to do. Carbon neutrality was always an amorphous term. Now they have better definitions of what carbon neutrality is, for instance. We're also talking about setting out in the rules to determine that a petitioner hasn't presented significant evidence or met its burden of proof without hearing from the other parties. In other words, this gives us what in court would be considered an ability to do summary judgment. So we would hear the petitioner. If the petitioner didn't come close to making their case, there's no need to go through the rest of the proceedings. We can just render a decision to dismiss or to deny without having to hear from OPSD or from the counties. We also want to insert a provision that allows us to dismiss a proceeding without prejudice if a petitioner doesn't have time to complete the process within the time frame. And this is something, by the way, I forgot to mention that the AG will be approving all of our proposed amendments before they come back to this. This is something we'll be discussing with the AG. We're also proposing to set a specific number and percentage of affordable housing and set a definition at what staff feels is actually affordable or workforce housing at 100% of median. We're also proposing to ensure projects have a Commission on Water Resource Management allocation and approval as part of the petition. We don't want to get into a situation where we've overtaxed an aquifer, find out afterwards that the Commission on Water Resource Management is not going to grant them permission to tap into the wells. We're also talking about having the sustainability coordinator sign off on things like the drainage plans and things like that to update our requirements or the county's requirements on drainage. We ran into this with the cemetery project that we approved a couple of years ago, and we were lucky that we had Dan Giovanni, who has an engineering background, and some others who recognized that the city and county's requirements on drainage were antiquated. We'd also like to update special permit decision-making to reflect the latest case law. This came from a federal court decision implying or stating that our rules were not specific enough and could be subjected to abuse. We generally would like to clarify the intent of the special permit section to make it clearer that when the SP process is used. Did you turn me off?
I
Heard
did.
enough from me?
Sorry.
It's okay. She shuts me up all the time. It's nothing new. In other words, clarify when the SP process is appropriate to be used, so we don't have the situation where we have petitioners submitting requests for special permits for, say, a school or a hospital that is more appropriate for a DBA. And that's kind of the heart of the rule amendments we're talking about doing. And at this point, what we'd like is the Commission's approval to move forward with making amendments to the rules to present to the Commission. And if the commissioners have any additional requests for amendments to the rules, that we would hear them now as well.
Thank you, Mr. Ornecker. So are you asking for immediate feedback on additional things to seek, or no?
Not necessarily. I mean, you'll have another opportunity when you see the actual rules. If someone has something right now, we can put it in right now, but I can understand if the commission would prefer to see our proposed rule amendments before they comment.
So you talked a little bit about the timing, the overall timing,
Yes.
but I presume that there'll be a first draft that starts to be circulated at some point.
Yes, we intend to have a first draft. What was the meeting date, Ariana? I forgot.
15th, November 15th.
In the commission's hands by November 15th.
November 15th.
Yeah.
Wow, that's great. So, in 6 weeks, you'll have a first draft. Can I ask that, will the commissioners have an opportunity upon receipt of that first draft to give you feedback within a given window of time, or is it?
We will submit that first draft to the commissioners. We're hoping 2 weeks prior to the meeting. And then you will have up until the day of the meeting and the day of the meeting to comment on the rules.
And if there's, for example, if there's an item that has come of interest to one of our commissioners that we'd like you to add or include that you had not done so, is that the appropriate, when that window is still open?
Yes, we can do that. We will actually post the rules for the public. I think we have to post them
Like 1 week.
a week before. Well, actually, I think it's less than that, but 4 or 5 days. But that, even if we post the rules, even if you don't get your comments to us, we can still make the amendments at the hearing via a motion and incorporate those into the draft. It will still be a draft that we will then submit to the Department of Business and Economic Development and the governor for permission to go to public hearing.
Okay. And the other comment I was going to make on what you've already said to us is I was very happy that you would include consideration to provide guidance to the prospective petitioners on when it's appropriate for a special use permit versus a DBA and vice versa, because that's been pretty problematic over the last few years.
Yeah, that is an area of concern for us, and one of the reasons we want to codify it is that the counties have different interpretations. And so we want to clarify for the counties that when somebody comes to them and asks them what they should do, that, no, they can look at the rules and say, no, the Land Use Commission's not going to let you do this. You got to do it as a DBA.
Fair enough. Okay, so before I entertain a motion, are there any questions or comments by commissioners? Oh, here's of our commissioner.
Mr. Chair, I have a question.
Please proceed. State your name and first.
Thank you. Commissioner Lee, Brian Lee, I should say, so you don't get confused with the other Lee. Can the changes be presented in a red line format so that we can better distinguish the
Yes,
changes?
they will be. They will be.
And then one other question. What was the thinking on, if I heard correctly, defining affordable housing as 100% of the area median income?
Well, to be honest with you, there's just been a lot of games played with affordable housing over the past 20, 30 years. And this is an attempt to deal with community input that we've had saying, look, 140% of median is not affordable. And what happens, or what's been happening, is that we've been leaving it to the counties. And the counties are very lax about it. And we've had situations where the only affordable housing that's been built has been 120 to 140% median. And that was not what the commission intended. So, this is just staff's opinion on how to deal with the problem, so we're open to.
No, I thank you for, I was just trying to understand your reasoning so that it was clear. I'm guessing it's so that it's clearer down the line what the commission means when it says affordable housing. Because as you're aware, there are different definitions of affordable housing. There's the HUD version, there's the county version, and there's the layman's version, right? So, okay, I appreciate that explanation. Thank you.
Thank you.
I have a question, Chair.
Commissioner Ohigashi.
Yes, that's my name. I just wanted to ask I wanted to ask.
sit away from each other.
Yeah. I've always wanted to
You
sit
and
on
George,
the
just
end.
get up and switch.
But what I wanted to make sure is that if there are any changes due to any type of court opinion or court that were noted in the proposed rules citation to those court rules, so that or court rulings, so that we can at least look it up ourselves too, and maybe get a gist of what was going on, and
We will,
see how it addresses.
yeah, we will also submit to the commissioners for their use a matrix that shows what the rule changes are about.
Yeah, thank you.
Thank you. Commissioner Okuda.
Thank you, Mr. Chair. I have a short request. If it's possible for you, Mr. Orendenker, to consult with Mr. Morris, Deputy Attorney General, to make sure we have compliance to the extent necessary with this case called Flores, Flores-case, CASE, Ohana versus University of Hawaii. That's 153 Hawaii 76. It's a 2023 Hawaii Supreme Court case that came down just about, I think, 6 months ago. We can debate whether it makes sense or not, but if you can just indulge me, let me just read the 2 short paragraphs which indicate possibly that some type of kapa'akai statement has to accompany the rule change. And this is what the Supreme Court said. Therefore, applying the kapa'akai framework to rulemaking, we hold that before adopting rules, agencies must consider, number 1, the identity and scope of Native Hawaiian traditional and customary rights affected by the rule, if any, semicolon. Number 2, the extent to which Native Hawaiian traditional and customary rights will be affected or impaired by the rule. And number 3, whether the proposed rules reasonably protect Native Hawaiian traditional and customary rights if they are found to exist, as balanced with the state's own regulatory right. I'm leaving out the quotation marks and the internal citations. And then this is what the Supreme Court seems to say as far as what has to accompany the the proposed rules, and I quote, although formal findings of fact and conclusions of law are not required, agencies must prepare a written statement summarizing the above analysis prior to adopting a proposed rule and make that analysis available to the public. When undertaking this analysis, the agency is not required to quote negative any and all Native Hawaiian rights claims regardless of how implausible the claim right may be, close quote. Where no Native Hawaiian right or practice is identified or implicated, the agency may say so in a short statement, and the need for the analysis ends there. And that's the end of this the paragraph. So my only request is if there can be a review to see to what extent, and even if it's necessary, to comply with this recent Hawaii Supreme Court case. I know the dissent, that's Justice Eden saying this doesn't make any sense, but this seems to be the ruling. Okay, thank you.
Thank you, Commissioner. We'll work with the Deputy Attorney General to make sure that we adhere to those requirements.
Can we take a moment? The mic's went offline. It says the mic's not working. I don't know what happened.
Testing, you mean these microphones?
For the Zoom recording, our staff can no longer hear us, he said. And it says the mic is not working, so I don't know.
Take a minute.
Yeah, bathroom break.
Okay, we'll take you want a 5-minute? Okay, we'll take a 5-minute recess. Thank So back to you, Mr. Orndenker. What is your request of the commission at this time? Please reiterate.
At this point, what we would request from the commission is a approval to proceed with drafting amendments to the rules based on the presentation that I made today, by way of motion, so that we can start working on the full draft.
Very well. Do I have a motion to authorize staff to draft the proposed amendments to the Land Use Commission administrative rules?
So move.
So moved by Commissioner Higashi. Do I have a second? So moved, seconded by Commissioner Atta. Would you like to speak to the motion, Commissioner Higashi?
No.
Can I implore you to speak to the commissioner your motion, whether you like to or not?
I think it's self-evident. I think it's time we move forward. So I'm in support of this motion.
Very well. Any other comments on the motion before us? Commissioner Carr-Smith?
Thank you. This is discussion, right? So I was just curious whether the counties will weigh in at all in terms of their overlap with LUC rules?
Well, the counties were noticed of this meeting and they knew what was on the agenda. There will be an opportunity for public input, which the counties can be a part of. There will also be an opportunity for the counties to comment at the next hearing that we have on this, which is going to be a virtual meeting, so everybody can be present from all of the counties.
Yeah, I have a similar question to that, which is maybe a corollary. Is it appropriate for you to notify for us to notify the counties that this is going to go forward and to request any suggested items for amendment from the counties themselves?
Staff can do that if the commission would like. We haven't in the past. We've just given them notification of what we're proposing, and then they know they can comment on it. So,
Yeah, I think I'd like to be a little more proactive in that respect. I don't know where you're coming from, Commissioner, but I think that the more that we can do to develop consistency in views and the way we conduct our business, that would be great. I mean, across the state, because one of the problems is each county kind of interprets for themselves. So when it comes to rules that govern our process, it seems if we give them an opportunity to weigh in on what's important to them, we might help breed a little more consistency across the state. So let me ask that the staff reach out proactively as you draft within the first 6 weeks and see if there are any specific items that they would like to have us address.
okay, we can do that.
Okay. Any other comments on the motion? Okay, so Mr. Orndenker, are you put your executive director hat on and call for a vote on the motion?
I believe we can do this by voice vote, Chair. I don't think we need to.
We don't need a roll call.
No, no, no.
Okay. All in favor of the motion to authorize staff to develop proposed amendments to our rules signify by saying aye. Aye. Any opposed? Hearing none, the motion is passed.
Thank you.
Okay, now let's go back to the agenda item that we skipped over while we were waiting for Mr. Morris to join us. And this is an opportunity for us to go into executive session to consult with the Commission's attorney regarding issues pertaining to Commission's powers, duties, privileges, immunities, and liabilities pertaining to status of outstanding litigations involving Land Use Commission And secondly, the implications of the governor's emergency proclamation relating to housing. Can I get a motion to enter executive session?
I so move.
Thank you, Commissioner Ohigashi. Who was the second? Thank you, Commissioner Kahele. All in favor of the motion to go into executive session signify by saying aye. Aye. Any opposed? Hearing none. Session, having concluded our executive session. This concludes our meeting. There's no further business. I declare this meeting adjourned.